I'm a commercial litigator. I'm a partner in the firm. The Foley Lardner is a international law firm with over 20 offices all over the United States and internationally. I have concentrated my practice over the years in a variety of commercial litigation matters, primarily in the real estate and construction area. And in the later years of my practice, I've become particularly interested in mediation as a preferred form of dispute resolution. So I've been doing a lot of mediating, both to settle my own cases and as a mediator to settle other people's disputes.
So, Tom, you've been serving as the neutral in resolving business disputes for a while now.
That's correct. Most of the mediation I've done recently has been actually in landlord-tenant matters, divorce cases, and small claims matters through the courts.
So, speak to our listeners, if you would, about the difference between mediation and arbitration, for example.
That's a good question.
Sure. Well, most people are familiar with litigation, which involves going to court and having your case decided by a judge or a jury. But there really are a number of other ways that cases get resolved. Arbitration has been around for a long time, and it basically can be thought of as litigation outside of the courts. The parties, by agreement, select an arbitrator. The arbitrator acts as the judge. The decision of the arbitrator is final and binding and can be enforced by the courts. Most people in the Boston area are familiar with arbitration now through the case of Tom Brady and have seen that arbitration awards can be overturned, although it remains to be seen what the final decision will be in that one. But for the most part, arbitration awards, once they're given, are final and binding, and courts will enforce them as long as the decision of the arbitrator was within the bounds of the agreement of the parties. Mediation is a very different process. In mediation, it's a voluntary, non-binding, and confidential process. It can be thought of more as a negotiation than really as litigation. It occurs generally once a dispute has arisen, but before it has been submitted either to a court for decision or to an arbitrator for decision. The parties get together with a neutral who can be selected by the parties or can be appointed by a judge if the court has that process going on. And the parties meet usually just in a conference room. They might discuss their case in a joint session first and then go into separate caucuses with the mediator. But the mediator basically acts as a facilitator to attempt to get the parties to reach an agreement if they can. And if not, the process ends with nothing being reported to the court or to anyone else, totally confidential, and the parties go on to one of the other dispute resolution mechanisms to resolve their dispute.